Hello students and welcome to the lecture. So students, as we know that we are covering the State Human Rights Commission, right? This is a topic on which we have been discussing right now. Okay? And if we talk about this, we know that these are the topics we have scheduled for the discussion, like the beginning of human rights, the human rights covenants, supplementaries of UDHR, beginning in India, chronology in India, introduction, composition of the commission, functions of the commission, working of the commission, Human Rights Codes, 2019 Amendment Act. Okay, so these are the topics we have scheduled for the discussion. If we talk about the topics that we have covered so far, so basically we have done with the beginning of human rights, we have done with the human rights covenants, we have done with the supplementaries of UDHR. The topics we are remaining with: beginning in India, chronology in India, introduction, the composition of the commission, functions of the commission, working of the commission, the Human Rights Code, and the 2019 Amendment Act. All right. So we can say that this is the picture that we have created so far altogether. So basically in this lecture, we will start from where we had left in the previous one. But before this, let me tell you one thing. Like in the previous lecture, we had, you can say, discuss over the supplementaries of UDHR. Okay. And what we had found that apart from the international bills on human rights, which included the three things: the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, the International Covenant of Social, Economic and Cultural Rights. Apart from this, there are other 20 principal treaties, okay, that are working for the human rights, and these treaties we oftenly described as the supplementaries of UDHR. Okay. Apart from this, we had discussed that basically the areas like the Eastern Europe, okay, like the Latin America, like the Africa, all right, and these areas are the areas which even extended the provisions of human rights by presenting the regional documents covering their area. Okay, so that has been the development over the period of time. That all we have discussed. So basically in this lecture, we will continue from where we had left in the previous one. So let's start. So right now, basically, this is the topic that we have covered in the previous one. Right now, basically, we are going to see it in the reference of India. Like so far, whatever history we had tracked down, okay, whatever the other things we had discussed, all these things were basically from the international point of view, like how the things were started in the international manner. Now we are going to take the reference of it with India, like how the things were happened in India, okay, and that is what we call as in beginning in India, okay, as the state human rights commission. Okay, so if we talk about the beginning in India, so we can say the policy, the pronouncements, and the human right education. Okay, the report given by various Indian education commissions and education policies. All right, so basically you can say these areas having the significant in the proclamation of the human rights education in India. Statements have stress on the importance of human rights and development in the educational system. Okay. And if we talk about the major commission and policy documents, like the first one was the University Education Commission that was constituted in the 1949. Okay. Thereafter, the Secondary Education Commission that was constituted in the 1952. After this, Education Commissions that was constituted in the 1964 to 1966. Then National Policies on Education, that is known as NPE, 1968 to 1986. Okay. Ramurthy Committee, 1992. Chavan Committee, 1992, were established to develop the concept of human rights in the education as value-oriented education system. So basically, if we talk about the evolution of human rights in the Indian contents, then the things are quite different with reference to India. Okay, like we can say if we talk about the other parts of the world, okay, and if we compare it with the beginning of human rights, the human rights covenants, and the supplementaries of UDHR, if we compare with them, so what you will find there, the implementation of the bill containing the human rights provision, that implementation was moreover the political oriented. Okay, like the political spheres were the one that were subjected to implement the human rights, and if they were failing to do it, so they were standing responsible for it. But when we compare it with the India, so India in the beginning had a different approach. Like instead of getting it through the political sphere, we choose the field of education, that is known as the human rights education. Why? Because if we compare the human rights and if we compare the fundamental rights, so for example, we can take the example of ICCPR, International Covenant on Civil and Political Rights. Basically, these were for the right to life, okay, freedom of speech, and voting rights. Okay. Thereafter, if we take the second one, International Covenant on Social, Economic, Cultural Rights, right to health, right to shelter, and all. So if we take them, so we will find that already these rights were in the Indian political sphere. Like if we take the first two one, like freedom of speech, voting rights, and the right to life, they were in the fundamental rights and the voting rights already in the Article 326. Okay. If we talk about the ICS ECR, which means the International Covenant on Social, Economic, and Cultural Rights. So the right to health, right to shelter, right to food, these were already in the directive principle of state policy. Okay. So already in India, you can say more of the covenants and more of the supplementaries were in the political sphere. All right. So that's why when we tried to implement this in India, so instead of applying it through the political sphere, we choose the education part. It means that if our generation who are in the school, who are in the colleges, who are in the university, who are preparing for various kind of competitive exams, if this young generation is aware about the human rights, they have got the clear-cut concept of human rights, all right, then what will happen? The upcoming generation, the future will be more brightened. Got it? That's why there was a thing. And if we talk about it, so we can say that the human right education was to be promoted for the promotion of human rights. And you can say there were so many reports that were given by the Indian Education Commissioners and education policies. All right. And the major of this, you can say the first is the University Education Commission that was constituted in the 1949, 2 years after the independence. After this, the Secondary Education Commission that was commissioned in the 1952. Okay. Thereafter, Education Commission that was constituted in the 1964 to 1966. Then National Policies on Education, NPE, that was constituted in 1968 to 86. Thereafter, the Ramurthy Committee that was constituted in 1992. And then the Chavan Committee that was constituted in the 1992. All these were established to develop the concept of human rights in education so that a particular value-oriented education system could be prepared so that our current generations and the upcoming generations would be aware about the importance of the human rights. Okay, why the human rights should be there. What is the principle to maintain the dignity and ethnicity with another person. Okay, so here you can see the difference between the approach of Indians as well as the world. Got it? So if we move forward, so we can say there is a chronology in India. Like, how does over the period of time the concept of human rights and the related acts were developed in our country? Okay, how does the things starting to happen? So here, if we try to find it, so we can say basically in the world, the concept of human rights were typically developed from the 1948 onwards. But when we compare it with India, so the things were not as much as equal to the world. How? Because if you try to find the chronology, what year you are seeing here? 1829. Okay, that was the 17th century. Okay, so basically in the 1829, the practice of sati was formally abolished. So what was the practice of sati? How many of you are aware about it? So you have 30 seconds to recall it. You have already heard it in the history. Then I will tell you that what do you mean by the practice of sati. So your time starts now. 10 seconds have been passed off. Last 20s are remaining. Last 10 seconds are remaining. Okay, time's up. So basically, if we talk about the sati, so sati was prevalent in the India during the medieval times, and even it could be traced back to the ancient times. Okay, in which what was the principle? Like if there is a married couple, the husband and the wife, and if somehow the husband dies due to the natural cause and due to any other cause, so what will happen? The wife of him will be burned alive with the creation of the husband. Okay, so that was a practice that was prevalent in India. And if we try to compare it with the ritual, and you can say with the belief of the Orthodox, so basically the sati is a term that is used for the Ma Parvati, okay, and goddess Parvati, and we know that she is the wife of Lord Shiva. All right. So basically, when the Britishers came to India, then they banned this practice. Okay, they said the sati could not be carried on as it is against the human rights. Okay, and we know that the practice of sati was one of the major reason, and you can say the restriction on this practice was one of the major reason why the revolt of 1857 was happened. Because if you trace back the causes of the revolt of 1857, there are four main causes: political causes, thereafter the economical causes, military causes, and last one was the cultural causes. And the cultural causes was the practice of sati was one of them. Okay. After this, in 1923, again in the colonial law, there was the Worksman Compensation Act. What was that? That basically there were so many complaints during the British time period. All right, like the factories, like the plantations, like the businesses that were owned by the Britishers as well as owned by the Indians. Okay, they were exploiting the workers who were working there. All right, they were, you can say, whenever the person got injured during the work, they just threw him out. All right, they did not pay any compensation to the person who got injured while performing the duty for them. All right. So basically, if we talk about the Worksman Compensation Act, so this act was formulated, and this act says if there is any person who got injured during the factory operation, during the plantation operation, and during working for the employer, then it is the responsibility of the employer that he should pay the compensation to him. And there is a particular formula for it. Okay. Like you can say, suppose the formula is like the present income of the person who was working and got injured, the remaining age he could work, and the you can say annual appropriation. So this is the Workman Compensation Act. Okay. Out of this, in 1926, there is a Trade Unions Act. There is a Trade Unions Act, and we know. Okay. Now, no. I'm going to ask you one simple question. That is very, very simple question and very interesting question. Forming a trade union is the fundamental right under the Article 19, the freedom of forming association. Is this the fundamental right? Yes or no? You have 40 seconds to think and answer, then I will give you the answer. So your time starts now. 40 seconds you have, and this is a very, very tricky and very, very easy question. If you have revised the previous lectures in the well enough manner, you will be able to give the answer of it in the very normal way. 10 seconds have been passed, last 30s are remaining. Okay, just think about it. 20 seconds have been passed off, last 20s are remaining. Okay, the last 10 seconds. Just think about it. Okay, so your time is up now. So basically, if we talk about the trade unions and its relevancy with the fundamental rights under the Article 19. So we know there is a fundamental right of Article 19 that gives the 6 freedom. Okay. You can say originally there were 7 freedoms. Okay. Like right to freedom of speech, right to, you can say reside, right to movement, right to form association, right to assembly, right to profession, and right to property. Okay. Then what happened in the 44th Amendment Act of 1978? The last one, the 7th freedom of right to property, that was abolished. And instead of the fundamental right under the Article 19, it had become the legal right under Article 300A. Got it? Alright. So basically now if we talk about the Article 19, so there was a one freedom, that is the right to form associations. So this right to form association is provides for the citizens that they could form the association, they could form the groups and all. Alright. But we know the fundamental rights are not absolute, but they are qualified. Means that there could be some restrictions could be put on the fundamental rights. So basically in this right to form association, there is a restriction that trade unions, or you can say forming the trade unions, is not a fundamental right. Okay. No one could claim that he could form the trade unions. But forming trade unions is the legal right which is promised under the Labor Acts and under the Industrial Acts. But it is not the fundamental rights. Okay. So remember this thing. So trade union acts were basically passed in the 1926 so that the laborers who were working under the Britishers and Indians, they could formulate their demand and could forward, you can say could put forward it to the employers. Thereafter, in 1929, Child Marriage Restraint Act. What is that? We know in the India, there is the privilege of child marriage. Okay. Usually the people, you can say, used to marry their children at the early ages. Even they were childs during that age. Okay. So in the 1929, during the British colonial era, the practice of child marriage was abolished. And various Indian reformers were there who were demanding for it. Okay. After this, 1933, Children Pledging of Labor Act. Okay. It means that the child labor was officially prohibited. Okay. Now let's move forward. Thereafter, in the 1936, there was a Payment of Wages Act. So most of the times you have heard about the wages and the salaries. Okay. So if I ask you like what is the difference between the wages and salaries, what should be your answer? Come on, tell me the answer. What is the difference between the wages and salaries? For this, you have the 30 seconds and I will give you the answer. So your time will start now. just tell me about the wages and the difference between the salaries. Okay. So 20 seconds have been passed off. Last 10 seconds are remaining. This is even important for the general knowledge perspective. Okay. So time's up. Basically, if we talk about the wages and if we compare it with the salaries. So wages are the day-to-day payout. Salaries are the particular payout, or you can say periodic payout. All right. For example, suppose if you are working somewhere, all right, and if you are working on the salary, then do you get your salary every day? No. Okay. You work for a certain time period and then you will get salary. Mostly the monthly time period. Like if you get the job and if you are promised to pay 30,000 rupees per month. Okay. So you are required to work from January 1st to January 31st. Okay. The entire month, and the salary of January you will get on the 1st February, or you can say any particular date of the February. Okay. It means that in the salaries, the payout will be made after the particular period that will be promised in your joining letter. Okay. If we talk about wages, so wages are different kind of things as they are promised on day-to-day basis. Promised on day-to-day basis. For example, if you have seen the laborers who are working in the constructions and all right. So basically they work on the wages like 300 per day, 400 per day. They are required to do a work for a particular hours, for example 8 to 10 hours a day, and then in the end of the day, after completing the 10 hours work, they will be paid like 300, 400 as the wages. So basically in the 1936 the Payment of Wages Act came into the picture. So you can say basically during the British time period, or you can say during this time period about which we are talking about, 1936. Okay, there was no particular limit on the wages. There's no particular prescription for the wages. So basically the employers who were hiring the daily workers, okay, whatever they want to pay, they wanted to pay. All right. Like suppose if the inflation is of 300 rupees, okay, it means as per the inflation, as per the living standards right now, it is required that a particular person is to be paid rupees 400 rupees or 300 rupees per day. But if there is no prescription, or you can say legal prescription, then what will happen? The employer could pay any amount, like 100 rupees he is paying, 200 rupees paying. So if you compare the paid amount with the needed amount, what you are finding? Is it sufficient? No. So to encounter this kind of situation, basically there was the Payment of Wages Act. It means that if there is any person who is working on the daily basis, and if there is any person who has hired this type of workers, then there is a particular limit the person is required to pay. There is a particular, and you can say there is a certain amount. Okay. So if we talk about today, then if you have hired the daily worker, okay, so they had the circle rates. Okay, like this particular area having the inflation of this much. Okay, then minimum this amount is to be paid throughout the day, like 300 rupees per day, like 400 rupees per day. Even if you move to the metropolitan cities where the inflation is high, where the living standard is high, so even the daily amount that is required to be paid to the daily worker, if he work for you, that is amount 700 to 800, okay, per day. So there is a Payment of Wages Act. After this, in 1946, there was the Industrial Employment Standing Orders. Okay, like you can say, if someone is to be employed in some industry, then there must be some formal employment. Okay, there must be some rights to the employee. Okay, there must be some, you can say, prescribed standards on which the person could be working in the industry. Okay, after this, in 1947, there was a Industrial Disputes Act. Okay, like if there is any disputes that arise between the industries and within the industries, then how these disputes will be dissolved. Okay, how the things would be carried on. So for this, there is an Industrial Dispute Act. After this, in 1948, there was a Minimum Wages Act. Okay, that is very much relevant to the Payment of Wages Act, but in the modified form. In the 1950, there was a Caste Disabilities Removal Act. Okay, like you can say, on the basis of caste, no person could be, you can say, declared disabled for some work. Okay, however, it is also applicable in the fundamental rights, the right to equality. But because I have told you, it is not necessary that the one particular right contains all the provisions. So that's why there are supplementaries also. So this one is the supplementary to the right to equality. Okay. In 1955, there was a protection of civil rights. Okay. In 1956, there was a Immoral Traffic Act. In 1961, there was a Maternity Benefit Act. Like if there was some woman who got pregnant and gave birth to the child, then at work, what are the privileges the woman should have and got from the employer? Thereafter, in the 1976, there was a Equal Remuneration Act. It means that if there is a woman and man, they are working for the same work, they are working for the same hours, then their remuneration, their payout should be the same. It is not necessary that the man should pay high and the woman should pay low. In 1986, there was the Environmental Protection Act. It means that it is a fundamental right and the human right of the person who is living in this country that he should get the clean environment so that he could live. In 1986, there was a Juvenile Justice Act. It means that if there is any minor who is not attained the age of 18, and if he committed something and if he got into some trouble, then how he will be helped out. So there is the Juvenile Justice Act. Thereafter, Commission of Sati Prevention Act in 1987. So you can say, however, this was prohibited in the 1829. But the sati was practiced on such a large scale that even in the 1987, there was a separate right required to abolish it. Got it? In the 1990, there was the National Commission for Women's Act. Okay. In 1993, there was establishment of Human Rights Commission, MHRC. Okay. In 2005, there was the Right to Information Act passed, and in 2010, there was a Right of Children to Free and Compulsory Education Act came into the force, etc. Okay, so you can say there were so many acts passed over the period of time in India to ensure the condition of human rights in the well-being manner. Okay, and we had just take an example of some of them. So students, basically in this lecture, we have finished it here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture and thank you.